Hello and welcome to the Mourant vlog series. In this short video I'll be looking at how terms which describe family relationships are used in trust documents and the evolving approach of the courts as to how those terms are interpreted. Common examples include spouse, children, issue and descendants, but the following comments apply equally to all expressions which describe a familial relationship between two individuals. Traditionally, the relevant legislation and common law rules in this area resulted in a restrictive approach being taken. So, for example, the meaning of children was confined to legitimate children. Illegitimate, legitimated and adopted children were excluded. However, as social values and the concept of the family have changed, more progressive legislation has been introduced in certain countries which seeks to alter that approach, such as by widening the meaning of children to include illegitimate and legitimated children, whether their parents are in same or opposite sex marriages or civil partnerships. Children born via assisted reproduction methods and adopted children are now also included. Likewise, statutory changes have resulted in the term spouse being taken to encompass individuals who are in same-sex marriage but not civil partners. Despite this, it's still open to settlers of trust to set out in the trust instrument how they wish these terms and others to be interpreted. So a settler could, for example, state that references to children should include or exclude illegitimate persons. As one would expect, human rights legislation and case law have had a significant impact in favour of treating all individuals equally, and there have been instances of the rules being applied retroactively in the context of the interpretation of trust documents. While they're exceptional, these cases introduce another dimension to questions around how terms which describe family relationships, particularly in older trust documents, should be interpreted. Over the last few years, there have been a number of instances of the courts in various trust law jurisdictions, such as Jersey and England, grappling with the issues which arise in this area in respect of trusts which predate the statutory developments I've summarised, or where those developments do not fully assist. And it's fair to say the courts have sought to reflect changing social attitudes and values and limit the potentially discriminatory effects of the terminology used in older trusts. In one of the Jersey cases, the class of beneficiaries of a trust was widened to include same-sex relationships, illegitimate and adopted children on the basis that that would be beneficial to the family in question, as it would maintain harmony within the family. Contemporary public policy considerations were also taken into account, and the court decided that these factors outweighed the weight it should attach to the settler's wishes, which were out of step with modern norms. And very recently, the English High Court has interpreted the term spouse to include same-sex spouses and civil partners. In that case, which concerned an employee benefit trust, as there was not much evidence of the settler's intention of how the relevant terms should be interpreted, the court looked at the commercial purpose of the trust and found that the settler wished to incentivise and reward the contributions of his employees and provide a mechanism for their dependents to benefit in appropriate circumstances, regardless of whether those individuals fell within the traditional meaning of the term spouse. The court was also asked to consider whether the term children should include stepchildren, but it could find no basis on which it should. That approach would have marked a significant departure from the common law position that references to children do not include stepchildren, and there was nothing to suggest the settler had intended for stepchildren to benefit in any event. The court was comfortable that this approach on this issue was not discriminatory, as children and stepchildren are, in relational terms, fundamentally different. It's now the case, more than ever, that settlers and trustees need to be aware of issues which surround how terms which describe family relationships are used in trust documents. In particular, it's important for settlers to be aware of how the meaning of terms such as spouse, wife, husband, children and issue will be interpreted, so they can consider whether to include bespoke definitions which are consistent with their intentions in order to change the default rules. Settlers should also consider recording their views in letters of wishes and equipping their trustees with powers that enable the relevant provisions to be amended in view of any future changes to those wishes and/or evolving social attitudes. Particular care should be taken when including any provisions which treat individuals differently on the basis of characteristics such as gender or marital status. Likewise, trustees should keep their trust documents under constant review and consider exercising their powers to tighten or broaden provisions as appropriate, if that's for the benefit of the beneficiaries, and to consider applying to court for assistance if their powers do not permit them to achieve the desired outcome. If you would like to discuss any of these issues or have a more general discussion about wealth planning under the laws of Jersey, Guernsey, the British Virgin Islands or the Cayman Islands, then please don't hesitate to get in touch with me or your usual Mourant contact. Thank you for watching.